Under the Service Member Civil Relief Act, SCRA, a military member who receives orders to deploy or relocate may terminate a lease for a dwelling unit, such as an apartment or house, by providing the landlord with written notice of the termination and a copy of the military orders. The termination is effective on the date specified in the notice, which must be at least 30 days after the date the notice is given to the landlord. The military member is still responsible for paying rent for the period of time covered by the notice, unless the landlord is able to rent the dwelling unit to another tenant before the termination date. If the landlord is able to rent the dwelling unit to another tenant before the termination date, the military member is only responsible for paying rent for the period of time the dwelling unit was vacant. If the military member terminates the lease under the SCRA, the landlord must return any security deposit, plus any interest due, within 30 days of the date the dwelling unit is vacated. It's important to note that the SCRA only applies to dwelling units that are leased by military members, and not to units that are owned by military members. Additionally, the SCRA only applies to military members who are on active duty, not to reservists or members of the National Guard who are not on active duty.